Okay. Hello, my name is Josh Blackman, and it's my honor to welcome you to the October term 2021 Harlan Institute Ashbrook Virtual Supreme Court competition. We are now in the round of 8. The top 8 teams will be arguing the case of New York State Rifle and Pistol Club versus Bruin. This is match number 1 for the round of 8, and we have from Lake Oswego High School in Oregon, Devin Von Arx and Lucia Zhang. And we have from Greenwich High School in Greenwich, Connecticut, Arjun Kishore and Nicole Orlovsky. Without further ado, we'll begin. Petitioners, you have 10 minutes. Begin whenever you're ready.
Mr. Chief Justice, and may it please the court. My name is Lucia Zhang, and along with my co-counsel, Devin Von Arx, we represent the petitioners in today's case. In September 2014, Robert Nash and Brendan Koch of New York separately applied for concealed carry licenses. Both of these permits were denied under the 1911 New York Sullivan Act. The law states that an applicant must demonstrate a special need for self-protection distinguishable from that of the general community or of persons engaged in the same profession in order to obtain a handgun permit. Today, we will argue that the New York State's denial of the petitioner's applications for concealed carry licenses is unconstitutional for 3 main reasons. It violates the Second Amendment right to keep and bear arms outside the home for self-defense. It fails under both intermediate and strict scrutiny, and it violates their 14th Amendment right to due process.
The operative clause in the Second Amendment guarantees 2 distinct rights: to keep and to bear arms. District of Columbia v. Heller concluded that keep arms was simply a common way of referring to possessing arms. In contrast,
Heller about possessing arms in the house, did Heller really say much about what happens outside the home?
Heller defined to bear and to keep, and they mainly applied the right to self-defense and carrying arms to within the home, but they did not limit it explicitly to just the home. So they gave some insight into the verb to bear as to carry, like a quote from Samuel Johnson's dictionary, and for confrontation and self-defense. So they strongly implied that this right exists outside of the home.
Let's talk about history, and I realize we have a lot of history in this case. Let's go back to the 1300s, and your friends on the other side talk about the Statute of Northampton, right? This is this 800-year-old statute. How do you support your case in light of the Statute of Northampton? Isn't there a very long-standing tradition of regulating carrying of arms outside the home?
Your Honor, the Statute of Northampton is an interesting document. The Statute of Northampton banned guns for the terror of the people. This is a very important part of it. It didn't just ban guns outright, but rather it banned guns in order to terrorize individuals.
But doesn't it show that the state does have some power to regulate carrying, whether it's for terrorizing people or otherwise? Are we limited to whatever they did in 1300s? That's it? We can't go beyond that?
No, Your Honor. So in terms of history, it's quite a bit conflicted. There's been cases such as Pennsylvania's state constitutions that clearly established a right to keep and bear arms for themselves and the state. There's also cases that the respondents would bring up where it is not the case. However, in a lot of state Supreme Court cases in regards to concealed and open carry, they've ruled that you need at least one avenue of exercising your Second Amendment right. So in the case before us today, while open carry is pretty much completely banned, the restrictions and the severe restrictions on concealed carry are thus unconstitutional.
Well, let me just pause you. So pretty much completely banned. Can you want to just explain what you mean by that?
Right. So in New York, Your Honor, the right to carry openly is a bit up in the air. So you can do like rifles and also like some historical replicas. But for the sake of an ordinary New Yorker, the right to carry arms openly is pretty much not available to them.
Okay, thank you.
I have a question. You talked in your brief, you cited the Caetano versus Massachusetts case in your brief. Now, suppose this court agrees with your arguments that the Second Amendment extends beyond the home, but then after this litigation, the government just adopts a regime that still denies permits for firearms, but grants everyone the right to carry a stun gun like Caetano. Would the government still be in violation of the Second Amendment under those conditions?
Yes, Your Honor, because the Second Amendment codifies the right to keep and bear arms, and arms generally apply to many weapons, and handguns are the most common household weapon. And so limiting it just to stun guns would be in conflict with the Second Amendment.
But is the right embodied in the Second Amendment the right to kill your aggressor or the right to your own self-defense? And if a stun gun will stop the bad guy, why isn't a stun gun good enough?
The right in the Second Amendment is, of course, Your Honor, simply the right to self-defense, not to kill anyone. However, we want to be able to use the most prominent and common types of guns necessary to exercise our Second Amendment right. And
But if New York allows everybody to carry a stun gun, I'm sure stun guns will be popular in New York.
Yes, Your Honor. But again, handguns are the most readily available. And again, arms does refer to weapons. And as established in Heller, that does include handguns. So limiting it just to stun guns would be in conflict with the court's interpretation of DCV Heller.
All right, thank you.
the Second Amendment is a fundamental constitutional right, not an exception or privilege that requires the subjective judgment of a government official, requiring a demonstration of an atypical reason to be entitled to this
Well,
right.
let's talk about that. So we have this good cause standard, right? How do you, okay, so let's assume I agree with you that the statute of Northampton supports your side and that the Second Amendment guarantees a right to bear arms. Why is the good cause standard not a permissible way to implement that right? What's so wrong about requiring them to show a reason why they need this right?
Good cause standard, Your Honor, requires an ordinary citizen to demonstrate an atypical reason to exercise a fundamental right. And I know a common argument would be sensitive places, as established in Heller, such as government buildings, schools, but there's a fundamental difference between a sensitive place and these objective regulations and good cause. These objective regulations take a baseline understanding of the constitutional right that applies to everybody and regulates it in certain places, time, place, and manner, and so on.
Aren't guns unique? You know, when we're talking about, does a felon get a voting right or something, right? Whether I cast a ballot for candidate A or B, no one's going to die. Aren't guns simply different?
Guns are dangerous, yes, Your Honor. But again, in regards to proper cause, we will go on to show using data and empirical evidence that the proper cause regime or the proper cause requirement is simply ineffective at increasing public safety.
Now you're getting into a policy debate. Oh, I'm sorry, Justice Greenlay. Did you want to jump in?
Oh, well, sure, if you don't mind. I just wanted to address you mentioned sensitive places. The population today in New York City alone is more than double of the entire United States when the Second Amendment was ratified. Shouldn't New York be able to apply the Second Amendment differently than the founders intended, considering how sensitive really the entire city of New York is?
It doesn't matter, Your Honor, how dense the population is. You have a fundamental Second Amendment right to self-defense. Being in a crowded city, honestly, probably just means there's more crime. The right to self-defense is greater.
And Your Honor, the idea of sensitive places was also established in Heller. And so Heller was 2008. And so by then the population difference between 2008 and now is very different than time of founding and now.
Well, you referred to, oh, I'm sorry.
No, go ahead, actually, Justice Greenlay.
Well, going back to the difference between today and the founding era and danger in public, I mean, and there was no standing police force until about the 1850s in America, like as we know it today. I think the NYPD is something like 36,000 patrol officers, 19,000 civilian officers. Why do we need the right to bear arms anymore? I mean, can't New York City, with a police force the size of small armies back in the day, I mean, can't they just say this right is really obsolete? We can protect our people.
Your Honor, that would be the case if crime was non-existent or severely negligible. However, that is not the case. For example, 34.3% of robberies in 2019 were street robberies, not by people that people knew, but just out of the blue street robberies. And that proves that the right to self-defense still exists because danger still exists. While these police forces may reduce the necessity of danger compared to back in the founding day, it does not eliminate it in any way that would be necessary in order to no longer need a Second Amendment right.
Well, let's say the NYPD doubled in size. Now it's up to almost 80,000 patrolling officers, or let's say tripled, 120,000, and there's no crime because there's a police officer every 50 feet throughout the city. Would we then be able to get rid of the right to bear arms in New York?
No, Your Honor. In fact, Your Honor, Robert Nash actually said as evidence for why he wanted his concealed handgun permit that there were robberies in his neighborhood. The reason one of our people applied for a handgun permit is in order for self-defense due to robberies. So if there were that many police officers, one, Robert Nash might not even apply for a handgun permit, and it would be a very different case. But two, you still will have some crime.
If there is no crime, Your Honor, that would be a question of removing the
But
Second
Counselor,
Amendment.
if we get to, if we're at the level of arguing about which is more crime, guns, more crime, as you said, John Locke, more guns, less crime, whatever, isn't that something to debate for the legislature? Why are we getting involved before these unelected judges sitting in our ivory chambers?
Your Honor, Heller explicitly eliminated rational basis review and they left intermediate and strict. Under both of these levels of review, it is the government's burden to prove that their regulation is substantially related or narrowly tailored to their compelling state interest. And they have not proven that, and there's a load of evidence to demonstrate that. And so therefore, if the government cannot satisfy the New York State's denial of the petitioner's applications, violate means and scrutiny, and the Second Amendment. Thus, we pray you rule in favor of the petitioners.
Okay, thank you so much. Very good. Respondents, you have 15 minutes. Whenever you're ready, you may begin.
Chief Justice, and may it please the court. The New York law should be upheld because proper cause requirements are constitutional. There are several key facts in this case that still need to be expanded upon. To the petitioners, Robert Nash and Koch, both were denied unrestricted gun permits, but received permits allowing them to hunt and for target practice. Koch was specifically granted a permit to carry guns off-road and backcountry as well as to and from work, and Nash was denied from carrying in areas typically open to and frequented by the general public. These petitioners' decisions were appealed and then upheld by a judge. An important element of the New York State law is that there is an appeal process by which applicants can appeal their decision to a judge, which indicates the presence of due process in the may issue gun permit regime. We will now go into the scrutiny standard, which we believe should be intermediate scrutiny.
Not so fast. Not so fast. Are you implying that because one of the petitioners was granted a permit to carry a weapon in the woods, that somehow protected his right to self-defense in a crowded, crime-ridden city?
No, Your Honor, and we're not claiming that. What we are claiming, however, is that the officer who granted this right looked at the specific situation of, I believe it was Koch, and saw that he would have police protection and would be in a highly urban area in New York City. However, when in rural communities, more close to where he lived and his travel to and from work, he would not have the protection of police and would not be in highly densely populated areas where his gun would be a greater threat to the public. So what we're saying is that the officer looked at the specific scenario that the applicant was in and applied the idea of self-defense with the threat that the gun poses to the public.
So are you saying that the officer was guaranteeing the safety of the petitioner in a city, but saying you're on your own in the country?
Your Honor, we're not saying that. Rather, what we're saying is that the judge looked at the applicant's need for self-defense and decided that he was able to have the gun within a rural area, but the need was not necessary in the urban area.
Isn't that interest balancing? Didn't Heller, the Supreme Court in Heller, say that we can't interest balance Second Amendment rights? That sounds like interest balancing. You need the right in the woods, but you don't need it in the city.
It's not, no, Your Honor, this isn't interest balancing. What we're pointing out is that there is an impact upon the general public. And this maintains standards with precedent. There's a long precedent going all the way back to the Statute of Northampton, as well as constitutional precedents, such as early colonial laws saying that when in public in crowded areas, you cannot carry guns because of the threat they pose. I'd like to refer specifically to the 1795 Massachusetts Act, which made it a crime to go armed offensively to the fear or terror of the good citizens of this Commonwealth, which shows there's a longstanding precedent.
That statute said armed offensively. It concealed. I mean, how is the public impacted by a concealed carry? Presumably, if the person who has a concealed carry permit carries it in or displays the gun in public or frightens people by displaying the gun in public, they could be prosecuted for brandishing, correct?
Yes, correct.
So then how is the public safety diminished by concealed carry if it's concealed?
Well, Your Honor, the reason is because guns are dangerous to the public. And this is something talk about extensively in our brief statistically, the impact that concealed carries have on whether it be escalating situations needlessly, whether it be chilling amendment rights, whether it just be confrontations getting more and more dangerous, hurting law enforcement officer. But Your Honor, to also add, the fact of the matter is when we're looking at something like this is a question that should be specifically led up to the legislatures. And the founders left this question up for the legislators for this exact reason. Legislators should look at the specific scenarios. They should look at the specific evidence to see what policy works most effectively to protect people's lives. And so for that reason, we believe this is a question of states and state legislators, not the Supreme Court making a decision for all 50 states without acknowledging any impact it might have on the public or urban
other
areas.
constitutional rights like the 4th, 5th, and 6th Amendments allow criminals to go free. So those are often dangerous too. The First Amendment protects hate speech, which can be dangerous. I mean, should the legislatures also be able to decide, in certain situations, those aren't very good rights either, and we shouldn't allow them to apply, maybe only when the government decides that it should apply?
No, Your Honor, not for those specific questions, but there are situations where fundamental rights, we most notably bring up parade permits, where state legislators can regulate fundamental rights.
Your Honor, we contend that the government has a vested interest in protecting and promoting public safety. And so it is important for the government to regulate certain elements of fundamental rights in order to promote the core of the idea, which is.
So counsel, let me interrupt you for a minute. So in New York, you have a good cost standard, right? You have to show good cost.
Yes.
Can New York just ban carry altogether 100%?
No, you wouldn't be able to ban carry altogether.
Why not? Why? Public safety, guns are bad. Ban all guns.
Your Honor,
Unless you're a police officer, you can't carry.
Because, Your Honor, that would be a violation of the Second Amendment.
Why? Isn't that why we're all here today, right? Why would it ban the Second Amendment?
Well, we contend that the proper cause requirement does not unconstitutionally burden rights under the Second Amendment.
Counselor, do you concede that the Second Amendment protects the right to bear arms outside the home?
Yes.
Yes, it does.
Yes.
Why? Okay, so why? Where does this right come from? How much of your other side, how much of the opposing counsel's briefs do you agree with them? Because a lot of the brief is arguing this right does exist.
Well, Your Honor, we agree with the fact that keep and bear are two separate distinct rights. But what we'd also like to observe is that these two rights should be regulated in separate ways, and states should have separate abilities to regulate these rights.
Your Honor, we also disagree with the petitioners on the grounds that they claim that the statute is unconstitutionally vague and would lead to arbitrary prosecutions. We disagree with that stance, and we also contend that the standard of review of intermediate scrutiny must be applied.
What about open carry? What if New York banned all concealed carry but allowed open carry? Would you be okay with that?
Well, Your Honor, we don't think that open carry is subject to the same constitutional protections in Heller because it flips the way that Heller is applied.
Is there more right to open carry than concealed carry, Counselor?
There's more of a right to concealed carry than there is to open carry because
why do you say that?
Your Honor, because Heller established a right to self-defense, to protect yourself from crime. Open carry flips the dynamic of protecting yourself and creates the public bearing of guns is often interpreted as intimidating and intimidation.
Look, if I'm open carry, no one's going to mess with me. It's a good form of self-defense.
Yes, Your Honor, but the need for self-defense is specifically more specifically under the idea of concealed carry, because often with open carry, the threat is
much longer history of people open carrying, and in fact, concealed carry is considered deceitful as a way to sort of trick people. Isn't that the history that we see?
Well, generally, Your Honor, that's correct, that open carry historically has been more precedent. Now, there's many reasons that has changed, whether it be the fact that handguns were not always accessible and that security forces were not really a thing until, as mentioned earlier, the 1800s. But the fact of the matter is, in the modern environment with urbanization, et cetera, we point to a variety of ways in which guns can needlessly escalate situations. And this is something that should be observed and something that should be studied to make policy decisions. It's not as if objectively, when someone open carries a gun, crime stops. So that's not always the case. And for that specific reason, we think that this should be conducted in the legislature.
I'd like to go get back on this standard of review argument that you were trying to get into a minute ago. Can you explain to me, first of all, do you concede that you lose this case if we apply strict scrutiny?
No, Your Honor.
So then what difference does it make whether we apply strict or intermediate if you think that you prevail even under strict?
Well, Your Honor, we contend that the standard of review is intermediate scrutiny because of the paradoxical nature of presumptively invalid laws. And for that reason, strict scrutiny would not be able to be applied in this case because as established in Heller, there are presumptively valid laws restricting the right to have
So
a gun.
hold
So
on.
because of that,
Do you think, Counselor, I'm sorry, when I speak, just try to stop. I know it's hard, but we have to sort
I
of,
apologize.
when, do you think Heller rejected strict scrutiny? Is that what you just said? Or Heller was inconsistent with strict scrutiny?
No, Your Honor, we said Heller rejected the rational basis review. And
No, I know,
left it
but you
up.
said that because they're presumptively sensitive places, that's not consistent with the strict scrutiny analysis. Did I mishear you?
Your Honor, we do believe that Heller outlines that strict scrutiny cannot be applied, and because of presumptively lawful regulatory measures, which do not solely apply to sensitive places, all other examples such as presumptively lawful to bail felons from carrying
So
guns,
if we
even if the
follow strict
felons.
scrutiny, we'd be violating Heller. Is that what you're saying? I mean, that's
That's
departing
correct.
from Heller.
That's correct, Your Honor.
Okay.
Yes, that's correct. we
What
would
standard
also-
did Heller in Heller applying to? What standard did Heller apply to the right to keep arms in the home?
Heller didn't outline a specific right to, it just simply outlined that the right to keep arms in the home was protected for individuals.
So wouldn't we be contradicting Heller by then applying this relatively weak intermediate scrutiny to the right to bear arms?
No, we wouldn't, because as Your Honor, because Heller establishes that they're presumptively lawful measures, which means on the basis, strict scrutiny on its basis.
Those presumptively lawful measures, I mean, the Heller limited them to bans on carrying in sensitive places such as schools and government buildings. What was the point of going specifically identifying places like schools and government buildings if carrying overall is sensitive?
Well, we believe that being sensitive or not is not binary, Your Honor. It's not simply schools are entirely sensitive and then the general public is 100% safe. We point to New York City as a prime example of this. And this is the exact reason that this gun regime is so effective.
Could New York City, could the state designate the entire island of Manhattan as a sensitive place? The entire island of Manhattan, from downtown to uptown, everything.
Well, no, Your Honor.
Why not?
We believe that, Your Honor, it potentially could be possible, but for several reasons, this would not be as effective because it's hard to outline, for example, borders specifically, and also
from downtown to 106th and Park. I don't know however you want to judge it, right? The entire island of Manhattan.
Sure, Your Honor, but even in that situation, we believe that that would be too broad of a measure to outline the entirety of the city. For example, specific areas within the city are more and less
place within
dangerous.
1,000 feet of a school. How about that? Could they do that?
Yes, Your Honor, the state of New York could do that.
Okay, so if you look at a map of New York City, there's 0 places that are not within 1,000 feet of a school. So you're back into the entire island of Manhattan.
Well, Your Honor, there's also, we point to New York City as the most common measure, but what we'd also like to outline is that this is about an entire state. There's multiple areas that these people could go. There's many cities.
Why can't we have upstate as a different rule, right? Maybe population density. Why can't Mr. Poe carry in Rensselaer County, which is not a fairly dense area?
Well, in effect, that's what this law does. It gives people who are educated and understand the structure and the buildup of the state the ability to make those decisions. So in effect, that's how this law actually works.
Your Honor, the law is not necessarily based on location of the applicant, but it does take that into account among a myriad of reasons for needing self-defense. So the applicant may demonstrate a need for self-defense that is partially based on where they reside, if it's in Rensselaer County, for example, Your Honor.
Sorry, Justice Kilmer, go ahead.
Thank you. You state in your brief on page 11 that an individual's safety is protected by the government in public spaces. And then you go on to say that security ranges from emergency responders to video surveillance, so that an increase in perceived safety in the public sphere, therefore the necessity of arms for self-defense is decreased. So my question to you is this, is how does the existence of emergency responders, who obviously show up after a crime of violence, and video surveillance that basically provides the evidence of the crime of violence, how does that protect the victim during the act of violence?
Well, Your Honor, we contend that that's not the only safety measures. Those are just some examples of safety measures, but we also have
What other safety measures? What other safety measures would help the victim who has a bad guy pointing a gun at them in the immediacy?
Well, if there's a person pointing a gun at someone in the immediacy, we would even contend that perhaps having a gun in your belt wouldn't be very helpful, but we point toward law enforcement officers on top of the fact that it's not even been shown that concealed carry decreases crime. In fact, as we point towards in our brief at multiple points, it has often been shown to escalate crimes needlessly.
So then you're agreeing with Judge Blackman, who said earlier that if we just have a police state, or it may have been Judge Greenlee, I don't remember, that if we just have a cop on every corner, we'll all be safe.
Well, not necessarily, Your Honor. We contend that the need for self-defense is still necessary if you have law enforcement on the street, but it is lessened given that we have a proliferation of law enforcement as compared to the founding era.
And this is also in line with, for example, how sensitive places function. As Justice Blackman was saying, in effect, that would be making all of New York a sensitive place. When you go into a school,
we just need to put metal detectors at all the bridges all the bridges that go into Manhattan Island, right? Everybody on Manhattan Island would be disarmed like they are in a courthouse. Is that right?
Well, if that were to be in effect, then perhaps that would reduce it. But we also point to the fact that there's a vast myriad of locations within New York. And the effect of this law is that it allows officers to look towards the specific instances and situations in New York to make informed decisions about it.
Okay, thank you, Counselor. Your time is up. Okay, 5 minutes for the petitioners. Whenever you're ready. I'm going to be rank quiz here. I'm going to force a time strict. Petitioners, 5 minutes begin whenever you're ready. Go ahead.
Mr. Chief Justice, and may it please the court. We want to begin with their argument about intermediate scrutiny and the idea of state discretion. State discretion is necessary, we admit that, but only with objective regulations. Again, this proper cause regulation is unconstitutional and ineffective. And they make the argument that this should be analyzed under intermediate, while we argue that it should be under strict. However, under both, the law would not satisfy. The data that they have and this comprehensive studies are different because our comprehensive studies illustrate that there is no established correlation between gun violence and also proper cause regimes.
Well, Counselor, let me just give you a thing, right? Let's say we rule for you, and the very first day Mr. Koch gets a concealed carry permit, he's carrying down the street, loses temper, and murders a child. How do you feel about that?
Your Honor, that would be obviously very devastating, but as the violence policy stated, less than 1% of the gun violence and the crime in the United States.
Mr. Koch is that 1%. He's at 1%. He murders a child.
Yes, Your Honor. But again, proper cause would not be effective. There is no data that proper cause would be what is stopping Mr. Koch.
Better than nothing. I mean, how many dead bodies will be sufficient for you to, maybe change your mind?
Your Honor, what would be necessary is data that shows the law before us today, which is proper cause, is effective at reducing gun violence. It's not. So while there may be other regulations, objective regulations, such as those in the Brady Act background checks, you need to take gun safety courses, that would be effective in reducing gun violence. This is not going to do it, and it's ineffective and unconstitutional.
The United States, it's a very diverse. I mean, for example, what works in a place like New York City, very densely populated, very large, it's a lot different than what might work in, let's say, like Meeker, Colorado, a small town on the western slope of Colorado. Why shouldn't we allow each state, like who is the judiciary, to come in and tell each location that, because this isn't reducing crime out in Meeker, Colorado, you in New York City can't do this? Shouldn't we just allow each place to decide what's best for themselves?
Your Honor, some state discretion is good and necessary. However, you cannot have so much state discretionary that it overrules a constitutional Second Amendment right. You can have state discretionary such as how many gun safety courses you have to take and things like that, but not this extent.
Can this court simply just define proper cause as including the right of self-defense in public? For example, that the right does extend beyond the home and leave in place all the other regulations New York has?
I'm not exactly sure what you mean by that, Your Honor. Would you say that they would eliminate proper cause or the atypical?
Well, being an appellate court, we get to define statutes. We get to say what terms mean in statutes. Can we simply say that the New York is required to apply the following definition to proper cause?
You know what?
Further,
I'm sorry. A lot of people feel they just don't feel safe. They feel uncomfortable. They even afraid that knowing that people in public who aren't police officers are carrying guns around them. Shouldn't we take their feelings into account?
Your Honor, though it would be sad if people not feel safe, I would actually feel safer personally, and so would the people who are defending if they had guns and I could defend myself. If there's a crime done against me, I want a gun so I can protect myself as I'm given in the Second Amendment.
So the people who feel differently from you, do their feelings not matter?
And the New York legislature
disregard
disagrees
them?
with you. Does the New York
Your
legislature
Honor-
not get a say?
Your Honor, their feelings do matter, but there is the constitutional right, and we are here to uphold the Constitution. And for that matter, if they don't feel safe, maybe they may feel safer knowing that these people have gone through gun training courses and that those who have licenses and carrying guns, they have a very low violence rate.
Okay, Councilman, that's time. All right, thank you so much. Whoo, boy, you guys are good. All right, everyone, yeah, come back on camera. Thank you so much for that. I think I'm speaking for myself and Don and Joseph. That was very impressive. We were really hard on you. We were interrupting you more than I usually would law students. And I didn't like, I ask you a question to give you a sense. I jumped right in. And I just think it's very annoying because I spoke over you, which is hard. I didn't give you a chance to finish your sentence. And I kept talking over you. And I kept flipping your direction deliberately so you couldn't even get a coherent thought out. That was a very impressive round. And I think you exhibited composure and calm. And you didn't lose yourself when I gave you these absolutely insane questions, like how many dead bodies do you want? I don't know, right? There's no answer to my question. There's absolutely no answer to my question. The only thing you can do is sort of just, it's like, kind of like a boxer. And sometimes you have to just take a punch and then sort of, okay, you took the punch, now you punch back. But there's really not even a good answer you could throw back to it. But that was very impressive.
Yeah,
I still don't know how 17 or 16, how old are you guys, if I can ask?
17.
17, 16, 17.
18.
Look at
17.
17. Look at these guys. All right,
We're
Don,
definitely-
Joe, do you have some feedbacks for the students?
You were definitely subjected to a hot bench today, folks. We call it, appellate lawyers call it a hot bench when you literally don't get 1 minute to say what you want to say, and you spend the whole time being interrogated by judges. And that's the most difficult kind of appellate argument, because you never know what the question's going to be. You have to have all your arguments at your fingertips. I do have one slight criticism of Nicole and Arjun. Arjun, you should let your partner speak a little more. She really was chomping at the bit to kind of get in a word edgewise, this is what's unusual for me is having dueling advocates. Normally it's one person at the podium, so you don't have to worry about one person dominating or not. But the two of you have two different argument styles, very good argument styles, by the way. Okay. But I wanted to hear a little bit more from Nicole.
And I think at one point, Arjun, I think you may have said something that was different than Nicole. I don't know. It seemed whether Heller rejected strict scrutiny. That's a very interesting argument. And I don't know if you were completely on the same page on that point either. I think you might have been. I'm not sure. Maybe you were. I'm not sure. But when you're doing this dual format, which is, Don, this is how high schoolers do it. I don't know why, but it's how high schoolers do it. When you have the dual approach, you have to be very careful to be on the same page and not get ahead of your partner. Because if you do, that just gives an opportunity to sort of rip apart. And then it's, anyway, but yeah, it's tough with the back and forth. And anyway, it's just as part of the format of the tournament that you have to sort of know to balance evenly. And there's just no way of doing it other than practicing it. But good, thank you. Joseph, you have some feedback?
Yeah, I thought you all did outstanding. I wasn't terribly surprised. I'd watched some previous rounds, so I've actually seen all of you guys argue before, and but it was just really, really impressive. And
That's not fair, Joseph. You should have recused yourself.
I
I've watched them since these guys were kiddies. It's okay.
Yeah, but very good, and your ability, as Professor Blackman was saying, just to jump from one. I mean, we were sending you in one direction, and then you'd get a few words out, then you go in the next. And your ability, all of you always had an answer on every single question. And I felt like you learned that you were probably going to get cut off like 5 words into your answers, and that you were getting directly to the point just in case. And as we did jump in and send you in a different direction. So I just thought it was very impressive, and you all did a really good job.
And,
Yeah,
and I
I'll
know
just-
we weren't tasked with grading your briefs. Apparently somebody else is doing that. But I did take an opportunity to read through the briefs. I thought the arguments in the briefs were presented very well too. And I think that your use of your briefs and your oral argument was well done. You linked the two very well.
You're also very polite, and like you'd stop talking. You know, when one of us rudely cut you off, you stopped talking as you should, and waited for the question, and you didn't disregard our question and say, "Oh, hold on, let me finish that last thought." You gave the answer that, you know, to the question that we wanted you to answer. So that was great too.
Very good. Another thing you did that I liked is your answers always began with yes or no. You didn't try and like go maybe, well, it depends. It was yes or no followed by the word but, right? And that's something that lawyers, Don and Joseph, had far more arguments than I ever will. But when you get a hard question, that's a yes or no question, right? When the judge asks you, is the answer yes or no? You got to say yes or no. There's not like a wiggle room. And you say yes, Your Honor, however, or no, Your Honor, but. And then you sort of try and pivot to your argument. A couple other feedback, and I think Joseph alluded to it. When a question's asked, your mouth has to close. It's one of the hardest things in the world to do, right? Don and Joseph, it's a hard thing to do, especially over Zoom, because there's probably a little bit of a latency. But when the question's asked, you just have to sort of stop talking. And that's something that only comes with practice. You know, I have, little kids at home. When they start talking, I have to talk over them, right? But the judge is the exact opposite. It's when the question comes, you stop talking. And that avoids crosstalk, because think of it this way, right? When the judge is asking the questions, that's really what's more important. What you're saying is somewhat secondary, because you're trying to figure out what the judge wants to know, right? Your argument, you know what your argument is. It's you're trying to perhaps address the judge's concerns, which may actually affect the outcome of the case. What else do I want to mention? To the extent that you can, when the clock hits 0, stop. You can say, Your Honor, may I finish my sentence, right? Or may I finish my thought? Right when it hits 0, and that's like kind of a respectful way of handling it. I think both teams went over, and in fairness, I think both Don and I asked you questions like towards the end, which was somewhat of a test to see if you go over, and you both did. See, I don't like being mean, but I deliberately like turn on the gas when I'm doing these things, because I would rather you get this now, because you'll remember this when you do moot court in college, and you'll never forget it, right? It's like, Your Honor, I see my time is up, may I finish? It's like, yeah, you can finish your thought, versus just sort of running through 10 or 11 seconds. And that makes me interrupt you saying, okay, you're done. And then it sort of makes it a little bit easier. All right, Don, Joe, anything else you want to mention?
No, I'm thoroughly impressed with all 4 of you.
Yeah, same here.
And always, I want to give a chance for you guys or the coaches to ask any questions of us.
Yeah, I had a bit of a question, which is, I noticed, we have like certain lines of questioning, and sometimes the lines of questioning sort of divert from the argument we're trying to present or ideas we want to get out. Is that a good thing or a bad thing? Because I've heard sort of conflicting things where some people say you want to try and redirect it into your argument, while certain people say you want to try and listen and address the judge's concerns. So is there sort of a balance there?
Don or Joe, you guys are the real lawyers.
Well, Josh is being unnecessarily modest, but if a judge is asking you a question, and Josh was kind of referring to this earlier, that means that the judge is focusing on that, and that may be what the case turns on. The judge isn't necessarily trying to be rude or say that the points you're trying to make aren't valid. The judge may very well agree with all the points that you're trying to make. But the judge also is on limited time, because there's a limited argument here. And the judge really wants to hear from you on this specific issue. And so it's important to focus in and try and anticipate what the judge is trying to why the judge is asking you the question. It may help you to answer it and stay on that. Redirecting back to your other argument, that's for the next judge. Most cases, oral arguments, unless it's a 3-judge panel and it's a long argument, you may only get one question from one judge. So that may be your only opportunity to persuade that one judge.
Yeah.
So yeah, definitely go and answer that judge's
You may not get back to that judge with that question. You may have one shot at that point. And to your point, Arjun, if you redirect, you may actually never get back to the point. There's like, well, they didn't answer my question. I'm gonna rule against them. So it's almost like you have to take every opportunity to answer the question that they're asking. And if you don't, you lose your shot. And it's so frustrating because like a couple times, I think I interrupted Don, and I apologize. Justice Kilmer, go ahead. You don't always get that in a real bench. It's time where the judges interrupt each other and you can't even answer the first judge's question. That will happen in some larger courts. If it's a state Supreme Court or the US Supreme Court, it might be 5, 7, or 9 members. They may be interrupting each other. And then it's like, who gets to go first? Joseph, I'm sorry, Joseph, do you want to address that question? I didn't mean to cut you off. I just said, look.
No, I mean, I agree wholeheartedly with what Don said. I think it's important. I mean, the judges are asking questions and often they come in with questions that they're not sure about and they really want an answer to. So if you keep going back, usually you would like to have made the points you really want to make in the briefing. And so the arguments you want to use for, at least in my opinion, to answer any questions that the judges have, not just restate the arguments over again.
Yeah, the way to think of it is this way. When a judge is asking you a question, that's an opportunity to make a point, okay? The judges have read your briefs. Whatever it is, whatever your prepared remarks are, they're gonna mirror your briefs anyway, so you've already spoken to those issues. If the judge is asking you a question, that's not a distraction. It's not meant to be mean. It is an opportunity to persuade the court and persuade that judge.
Any questions from Nicole or Lucia or Devin?
I had a question. So when you have a new case, how do you go about preparing and doing research, and what's your process?
That's an excellent question. Joseph, you want to start?
Sure. Well, I read over the pleadings, or if it's even before the pleadings. Usually I address things once they're on appeal, and then there's a record, and I just reread that over and over and over, and really get the facts known of the case. And then usually, because I focus a lot on especially Second Amendment, usually I have an idea of what the arguments are in the case law and the history, when an issue comes to me, and it's really just learning the facts and then trying to see how it ties into, the favorable history and all that. And then always in the back of my mind is, what's hurting me and what am I really going to have to address and resolve, what helps the other side that I'm going to have to.
Yeah, I mean, Don, you've taken some gun cases from the very get-go, from the ground floor, haven't you?
Yeah. Whenever I'm working on a new problem, whether it's filing a new case and how I want the pleadings to look, or it's a case that's already been litigated and I'm working in the appellate courts, the one thing I do is like Joseph, I read everything that has to do with the case. Okay. And I don't necessarily go read the case law because I'm already familiar with a lot of it, but I read everything that has to do with the case. And then I go out and do some physical activity. Okay. I'll go canoeing. I'll mow the lawn. I want my brain to kind of chew the ideas without sitting at a computer screen or the distraction of Lexus in the background or anything. I just want to do something that's kind of solitary and physical. Okay. Go for a bike ride or something, and go for a walk in the forest or something like that. And that's when the facts sort of start settling on your brain, and then you become familiar with it, like a novel or a story that you want to tell. And then you go do your research, and then look at the facts again and look at the record and evidence again. And that's at least that's my process.
Yeah, I agree with that for what that's worth. I never start writing a brief. I especially like to wait until the next day if I can. I mean, I'll read through everything, and then I think it's really good. It works. You could probably research this and find out a better explanation, but I think it works different parts of your brain, and it sets in if you do something active, sleep on it and stuff, and then think about it. But like a lot of times your brain's working even though you're not intentionally making it work on that, if that makes sense. So I always try waiting until the next day to actually start writing anything.
And let me answer the question a little differently. I mean, you're all assuming that the case is something that's even known. A client might come to you and want to bring some sort of novel cause of action that's never been done before. And that requires a judgment. Is this even a case that can be litigated, right? Not every grievance that people have belongs in court. And not every grievance people have is actually meritorious. Maybe they may be a losing case. So you have to even think, is this something that's worthwhile bringing? But your question is a good one. There's what I encourage everyone to, all four of you, if you know any lawyers, right, ask to shadow them for a day, just for a day or a weekend or a week or whatever you can spare for your school. Shadow them for a couple of days and just look at what they're doing on a minute. And trust me, lawyers bill in 6-minute increments. So every 6 minutes their day is accounted for, right? So see what they're doing on a given day from 9 till 9:30 and from 10 to 11, whatever it is. Right? They go into a deposition, are they researching, and just follow them all day for a day. Take a, maybe during summer break, it's a good thing to do, right? Follow a lawyer for a week. And I think you'll see that the sort of things we do are not like, it's not cookie cutter, right? It's not like template. Every day is going to be a little bit different and you might enjoy it.
Yeah, or it may get you to go to HVAC school.
Oh man, get a degree in air conditioning repair, probably make more money than we do. That's good money. That's not, I'm not joking. You make a good living with and you have no student loans either, no debt. Look at these guys. HVAC, yeah. What other questions you have, Lucia or Nicole?
Yeah, I had a question.
Sure.
So when forming your argument, how do you balance the historical precedent and kind of using elements from the founders era versus more contemporary examples and more recent legal precedent? And how do you weigh those? Do you place more emphasis on one or the other in kind of formulating your arguments?
Really good. Joe or Don, you want to take it? Because you guys have litigated for the Ninth Circuit for a long time, so maybe there's a good question for you.
Well, I think really you want to do what's most favorable to your case and say that's the circuit courts have this two-part test, which I think is different from what the Supreme Court does, and I guess we'll find out in a few months here, most likely, which one is appropriate. But the two-part test at the circuit courts, which are the courts right below the Supreme Court, first it asks about the history. It says the original scope of the right. Does this law burden conduct protected by the original scope of the right? And then, if so, it goes into this heightened scrutiny, that intermediate and strict scrutiny we were arguing about today. And I think you want to focus on whatever is most helpful. I mean, you have to satisfy both of them with the two-part test, but a lot of times, if the scrutiny part is really favorable, like courts will just jump over it. They'll just say, we'll assume that it burdens conduct because we know it satisfies scrutiny. So I like focusing a lot on whatever is most helpful to your case.
Yeah. One of the fascinating things about Second Amendment jurisprudence is it seems to have resurrected in the past 20 years as an emphasis on review of historical documents and the original public record of what people thought at the time that the amendment was put in place. That's not necessarily the case with other areas of law, though. I've litigated tons of Fourth Amendment cases and some First Amendment cases as well. And in those cases, the courts usually focus more on the most recent cutting edge Supreme Court case. Now, of course, the reason for that is that there's almost 100 years or 150 years of the Supreme Court writing on these other rights. Okay, whereas the Second Amendment was kind of ignored and pushed off to the side, and there was only one case in the 1930s, and then we had nothing from the Supreme Court until 2008. So part of it has to do with the specific subject matter of the Second Amendment, whereas in other fundamental rights cases, you're going to be looking at more contemporary cases that the court is built on.
One other thing, it might also depend on the philosophy of the judges that you're trying to persuade. If they're really concerned about the original understanding of rights, then that might be a reason to focus on that more. And of course, if they're not too interested in what the founders thought as much as how things apply to today, or applied today, then that's something to consider too.
Yeah, this is where researching your judges sometimes helps. Reading their opinions on other cases, whether or not they were a history major in their undergraduate work or a political science major or something, that it never hurts to have a little bit of to know your audience. And when you're arguing to the court, your audiences are the people in the robes.
All right, maybe one more question because we have another round starting in a few minutes. Lucy, anything?
When it comes to oral argument, what's like your general mindset for what you want to get to, what arguments you think are most essential, and what you cover in like your main argument?
Here's a hard and fast rule. You probably, if you have a loser case, you're not going to win it at oral argument. But if you have a winning case, you can lose it at oral argument. Okay, you need to understand those subtle
Sure,
distinctions.
that's absolutely what he just said is so true. You can lose a case at arguments. You can't really win one, right? But you can lose it. That's Joe. Yeah. I've seen lawyers step into it, and the usual way this happens is the judge asks them a question, and they say, "Counsel, would you agree that X?" And they say yes. And then it's like, "Well, you said Y in your brief." It's like, "Uh-oh." And that's why I was pushing so hard on the scrutiny question, because that's one of the things you could lose the case on, right? Some teams in this competition have actually said, Your Honor, we concede under strict scrutiny, we lose. And I think that's a position you can take. I mean, that's fair, right? But you need to be able to recognize the consequence of those actions if you make those things. Anyway, all right. I do want to wrap this up shortly, but I want to say thank you so much to the teams, both petitioner and respondent. You give me such hope for the future that we have people 16, 17 years old making arguments with the statute of Northampton and discussing really complex issues and holding their stuff together. You all will go to college in a couple of years, 1 or 2 years. You better do moot court, right? Go do mock trial. Go take your LSATs. Go to law school, and then email when you do, because I want to see where you guys wind up. But you're going to do great things in your lives, I'm sure of it.
Thank you so
Thank you
much
so
for being
much.
here, and also thank you to the
course.
respondent team. Yeah, you guys did a good job.
You guys were amazing.
Yeah, thank you very much. Have a nice
See you.
day.
And you have all your information. You want to email each other, email me, get in touch with me. Thank you so much. I will, if the students and the coaches can sign off, I'll call this round to a close. And I have another round starting in 4 minutes. So see you soon. Thank you.
Thanks.
All right, let me turn this recording off. 1 moment.
I think I'm up for the next round too.
I think you are, Don.
Oh, that's right.
Yeah.